All right, hello. I guess we'll go ahead and get started. I want to thank everybody for coming out this evening. My name is Vikrant Reddy. I'm with Koch Institute, a 501c3 organization in Arlington. We We introduce folks to the ideas of classical liberal thought. We've got a lot of terrific educational programs for young adults, for young professionals, for students. If you're interested in those, I encourage you to talk to me or others on the CFAA staff at the end of today's event. In any event, we are here today to discuss the Computer Fraud and Abuse Act and the issue of overcriminalization. Now, overcriminalization is a really interesting word. It's one that I first started hearing in the late 1990s. I'm sure it goes back even earlier than that. I do know that the first time the word ever appeared in a Supreme Court opinion, body of a court opinion, was just 2 years ago. So I get the impression that although people who are in the criminal justice wonk and policy world are very familiar with it, a lot of folks are just now beginning to understand what it means and what it's all about. Broadly speaking, overcriminalization refers to the idea that we simply make too many things crimes, too many activities and day-to-day American behavior have become criminalized, the kinds of things that you never would have contemplated criminalizing decades ago. It also refers to the fact that a lot of things that traditionally were handled as state and local crimes have now become federalized. It refers to the fact that intent requirements for crimes, which were fundamental to criminal law dating back, I was going to say to the beginning of the American Republic, but really before the American Republic, dating back to British common law. Those kinds of protections have begun to erode. So overcriminalization encompasses this very broad array of phenomena. People who are in the policy world know that when you talk about policy concepts like this, you're encouraged to tell stories. And in the overcriminalization world, there are all sorts of interesting stories. Where I grew up in Texas, and where I worked for many years in criminal justice, the Texas Public Policy Foundation, we found that we resonated with a lot of people when we told overcriminalization stories about people who were threatened with prosecution for things like helping injured deer on the side of the road, things like catching oysters the wrong time of day, all sorts of very unusual stories. I moved to Washington about a year ago, and I got the impression that these stories weren't clicking quite as well. And I guess it just has to do with the fact that Washington's full of a lot more city folks. They don't deal with deer and oysters on a day-to-day basis. However, then the Nosal case came down, and the argument was made in this opinion that we're going to talk about a little bit today, that you could arguably be committing a crime for sharing a Netflix password. And I know that every person in this room has done that. And those of you who say you've not done it are either lying or you're terribly sanctimonious. See, it happens. We're going to talk a little bit about the Nosal case today. We're going to talk about the Computer Fraud and Abuse Act more broadly. We're going to talk about overcriminalization as a phenomenon in the country. To do that, we've got three terrific experts on the subject, whom I'm going to introduce right now. Immediately sitting next to me here is Jamie Williams, who's a staff attorney on the Civil Liberties team at the Electronic Frontier Foundation, which is based in California. She works on First and Fourth Amendment implications of new technology. She joined EFF as the Frank Stanton Legal Fellow. She previously clerked for Judge Sandra Brown Armstrong in the Northern District of California. She was also an associate at Paul Hastings LLP and a law clerk at the Alameda County Public Defender. She's got a BA in journalism from the University of Wisconsin-Madison and a JD from UC Berkeley, where she now teaches a course, teaches at her alma mater. Next to her, we've got Gabe Rottman, Deputy Director of the Freedom, Security, and Technology Project at the Center for Democracy and Technology. Gabe works on issues related to computer crime, surveillance, and cybersecurity. He was previously Legislative Counsel and Policy Advisor to the American Civil Liberties Union, focused on technology, free expression, open government, cybersecurity, and privacy. He's testified before Congress and frequently appears in media. He's got a joint BA from McGill University in Montreal in history and political science. He also holds a JD from Georgetown, Washington. Finally, we've got Paul Rosenzweig, who's the founder of Red Branch Consulting, a Homeland Security consulting company. He's also a senior advisor to the Chertoff Group and he is a visiting fellow at the Heritage Foundation. Paul formerly served as Deputy Assistant Secretary for Policy in the Department of Homeland Security. He is a lecturer in law at George Washington University, an adjunct professor at National Defense University, and senior editor of the Journal of National Security Law and Policy. His bachelor's degree is from Haverford University. His master's degree in chemical oceanography is from the Scripps Institution of Oceanography at UC San Diego, and his law degree is from the University of Chicago Law School. Thank you guys for joining us today. Jamie, I'm going to start by just asking you to help us define our terms. What is the Computer Fraud and Abuse Act?
So the, oh, great.
Actually, let me,
Yep. Won't work.
Maybe. Is this even on?
It's not even, that doesn't work even though.
Okay. So the computer,
don't worry about it, okay.
all right.
Well, we're going to talk about what the Computer Fraud and Abuse Act is, what was it supposed to be, and what isn't.
So the Computer Fraud and Abuse Act is the federal anti-quote-unquote hacking statute, which was passed in 1986, which was a long time ago. It was, again, intended to target computer break-ins, people who are breaking into computer systems to access information, and bad actors. It was actually passed in part in response to, some members of Congress watched in hearings the 1983 techno thriller War Games. I'm not sure if anyone here has seen that movie, but it was portrayed as a realistic example of the threats of hacking. And so this movie, for everyone who doesn't know, is about a kid who thinks he's playing a video game, but in reality he's starting global thermonuclear war. And so he's actually, this evil computer is working with him, and it starts this World War III scenario. And so this freaked people out. And at the time, there were already wire fraud and other types of statutes that could cover some of the computer abuse, computer misuse, computer break-ins that were happening. But Congress wanted to do something more, and so they passed this law, which prohibits accessing a computer without authorization. There's various different provisions, but all of them have that without authorization language. And it's hard to understand what that means. And one of the reasons why it's problematic and why it's so vague is because 1986 was basically right at the time the internet was being born. ARPANET had just switched over to the modern day internet, and so it was very hard for Congress to actually understand how we were going to use computers today, because we didn't even know. So that's where we are.
Okay, so let's talk about a practical application of this, and let's just get right into Nosal right now, which I think is the case everybody's curious about. Gabe, I'll turn to you if you don't mind. Could you just talk about what the U.S. versus Nosal case is, how it applied the Computer Fraud and Abuse Act?
Sure. So the Nosal case that just came down is actually the second of two cases that both deal with the same factual scenario, which is actually pretty typical in CFAA cases, but effectively you had some defecting employees of an executive search firm who were taking information to use in their new startup. In the first Nosal case, they used their own passwords to access that information and then exfiltrate it over to their new startup. And the Ninth Circuit held in that case that wasn't a violation of the CFAA because they weren't acting without authorization. In the case that just came down, Nosal 2, once they had left and had their authorization to access the database revoked, they actually asked the lead person's executive assistant to stay at this at what would then be the competing search firm, and they asked her to stay. She gave her password to a couple of the defecting employees, and then they accessed the database. And the majority in Nosal 2, a 2-to-1 majority, found that was in fact a violation of the CFAA because the employer had revoked the authorization of these employees. But the dissenter, Judge Weinhardt, said this is a case about password sharing, pure and simple. She shared her password, they used the password to access this database, she had authorization to access the database, even though they did not. The fact that she had authorization means that they could not have been acting without authorization. And the reason why it's so damaging, some have argued that the case will be will be limited to its facts. But Judge Reinhardt said, really, there's no limiting principle here, because what happens if you share your Netflix password with your wife? What happens if you share your banking information with your husband, who then goes and does something that you haven't expressly told your husband to do? All of those things would be without authorization under the broadest read of the majority's opinion. And Judge Reinhardt said there's no limiting principle, and that's where we are with Nosal.
Yeah, please.
And one of the reasons why this case came up is because the CFAA doesn't actually define what authorization means in the first place, or who it must come from. And so in this case, you're talking about the employer and then the account holder. So the court was saying only the employer is the computer owner, because we're talking about their database and they own the database, so they're the computer owner. And the court basically said in its reasoning that the authorization given from the current employee, the account owner, didn't matter. The CFAA is absolutely clear that authorization needs to come from the computer owner. And so they have this really wonky footnote in there. And so that reasoning suggests, for them, the authorization given from the account holder, the employee, completely didn't matter. They said this doesn't even count. And so that reasoning is what the dissent latched onto and said, well, that reasoning makes no sense, because then if I gave my password to my husband, then unless he gets it specifically from Netflix, then he doesn't have authorization. My giving him the password doesn't matter at all. And so that's why the decision is very problematic.
Paul, you said to me when we were talking about this on the phone a little bit that one interesting implication is that you've essentially allowed private actors, corporations, for example, to define what is and isn't criminal if you do it this way.
No, I think that's right. Before I begin, I want to dissent from the view that Joshua was an evil computer. Joshua was a young computer trying to learn its way, and happened to do so by playing global thermonuclear war. And if you haven't seen it, Matthew Broderick, Ali Sheedy, great movie, 1983, still speaks to us today in a lot of ways. Not the least of which is we're all against global thermonuclear war. But to your point. The CFAA is odd in the way it is constructed, because it says without authorization, but then it leaves that definition of authorization empty of statutory meaning. Now, you can imagine a scenario in which authorization is defined by technical capability. If I can access it without breaking something or defeating a protocol that is designed to prevent me from accessing it. If it's open and accessible, i.e. I have a password and a username and I can access it, that would be authorization, and we measure it in what is essentially a relatively objective, there'll be great cases of course, but relatively objective measure of technical capability. But that's not the direction that the courts have generally taken. What they've generally taken is a definition of authorization that relies upon the subjective conveying of intent by the owner of the community. I mean, I have no doubt that Nosal's former employers really did not want him to get in. And so in that kind of meta sense, he was unauthorized in his access. But there are two problems with that. The first, which is the one that you mentioned, is that somehow we've delegated the definition of the scope and applicability of a federal criminal law to the expression of intent and desire of a private citizen actor. Right? We don't do that anywhere else. It's not as if we say it's an illicit drug if you think it's illicit. But if you think it's licit, well, that controls and that's okay, you're authorized. Or we don't let some doctor determine authorization or not. If there's a schedule of illegal drugs and we go through a process and you might like that they're on there or not, but it's defined by a governmental entity. Here, the scope and application of the law is defined by what Nosal's employer says, what Netflix says, what Facebook might say about access. So that's the first problem. And then the second problem is buried in what I said about my lack of doubt about Nosal's employer's intent. That was probably pretty clear, but in many, many, many instances, the subjective intent of what the person on the other side is actually trying to convey as the limits of authorization are very gray and very uncertain. And so we've built a rule in which private actors define it, and people who act in this space are at the mercy, essentially, of an indefinite expression of intent from somebody who they may never even convey, never even speak to. If the example I gave you on the phone was yeah. So say I create a website, the URL of which is www.whitepeople-may-not-look-at-this-website.com, or black people, or but whatever. And the first screen says, if you're a white person, go away. This is not a website for you. It's only for non-white actors. But I do nothing technically to stop you from coming to the website. So if you can type that in, you get the website and it pops up. Is the fact that there's no technical barrier what should define authorization, or is my subjective intent to keep you out? And then if you think that that's clear enough, we'll just turn it into an alt.right website or some other thing where the exclusion is implicit and not explicit. And it's so all of which is to say that criminal law is intended to be definite. It is intended to give people a reasonable understanding of what is prohibited. Again, there are gray areas, but murder's illegal, right? It's not like there's a lot. Here, you can't know. You act at your own peril. You can't know what's criminal, and the result is 20 years in jail. Yeah, maybe.
Generally speaking, criminal statutes have, or certainly they're supposed to have, some kind of a mens rea requirement, an intent requirement that provides for these kinds of things. Maybe, Paul, if you could just for a minute discuss what mens rea is. I know you're a former criminal law professor. You should be able to communicate in mens rea. And I would also ask what sorts of mens rea protections are provided for in CFAA?
Well, how many of you are lawyers out there? Just before how many of you think you know what mens rea is, right? Okay, so maybe I don't need to do, but mens rea is the expression of the idea, the core criminal law idea, that you go to jail if you willfully, purposefully, intentionally do something wrong. If I trip as I get off of this and punch Gabe in the face, right? That's not a criminal assault because I didn't intend to. I tripped and I fell, right? If I haul off and wham him in the face, that's an intentional act, and I would rightly go to jail. Not that I'd ever do that, Gabe, because you're my friend.
I would drop the jail.
Oh, good. Thank you. So maybe I wouldn't go to jail. But it goes back to the idea of bad acts and guilty minds, which is the very, very long saying criminal law back into English common law, the idea that civil law addresses civil wrongs. I mean, if I tripped and fell and I punched Gabe, I probably have to pay for jaw reconstruction. But it does not, but criminal law addresses purposeful, willful criminal activity. And what we've seen in the last 100 years, 50, more accelerated, is the erosion of that intent, so that it is no longer requires what I've described, which is kind of a specific intent, but a general intent to do the act which constitutes the offense. So, for example, in the CFAA Act, the intentionality that the court's trying, that the prosecutors want to impose, is the intentional act of accessing the website, typing in the URL. And since nobody types in a URL by accident, they've met the bar of purposeful activity. Whereas the right purpose should be, accessing that website with the intent of stealing information from it, or with the intent of destroying the data on the computer. And so in the CFAA, one of the debates is about which intent there is, and it's an ongoing debate. The courts are split, but the prosecutors are routinely saying that it's merely doing the act which constitutes the offense. And since everybody accesses a computer purposefully, they don't, except in the rare case of butt dialing,
It's not so rare.
Well, it's not so rare, but I mean that would be your only excuse. I butt dialed that URL and accidentally hacked it. Well, I've used it.
Jenny, let's talk a little bit more about the legal issues involved here. I'm just really curious about the odds of the Supreme Court taking up this case. I also know that the Ninth Circuit tends to get reversed a lot in the U.S. Supreme Court. What happens next in Nosal specifically?
So in Nosal, well, there was also another password sharing case out of the Ninth Circuit called Power Ventures. It's a civil case. So 'cause the CFAA is actually both a criminal and civil statute. And so there was another password sharing case, Facebook versus Power Ventures, which involved, kind to sum it up very quickly, which involved it's kind of complicated. A social media aggregator who, so if I was a Facebook user and I also have Twitter and all these other ones, a bunch of years back, so the players were slightly different, but I wanted to be able to go to one website and access all my content, and then I could click on it and be directed back to Facebook and go to Facebook there. But I'm going to leave out some of the other complications of the case, but Facebook didn't like this. It was right around the time that they were rolling out their API, and they sent Power Ventures a cease and desist letter that said, hey, stop doing what you're doing. They also set up an IP address block, but it was ineffective because Power Ventures had a dynamic IP address, so they blocked an old one. And so Facebook waited about a month, and then they ended up suing under the CFAA. And so it's a password sharing case because in order for them to get the Facebook data, the Facebook users had to voluntarily give their Facebook usernames and passwords to Power. And so it's slightly different, the holding is slightly different from Nosal because the Ninth Circuit, a different panel, these decisions came out within a week of each other. So we're talking about 3 different judges in a very similar case with, different details. And the court said that initially someone, an account holder, can give a third party their authorization, and that authorization is valid under the CFAA. But if the computer owner here, which would be Facebook, comes and says, hey, you actually don't have authorization, this was via a cease and desist letter, which was citing violations of their terms of service, then the authorization is gone. You don't have it anymore. And so in that regard, it's slightly different than Nosal because it's saying that it is possible to have an account holder giving authorization. Does that make sense?
And then revoke.
Yeah, and then it can be revoked.
With the cease and desist.
I have a lot more sympathy for Facebook than I do for Nosal's employees, because they actually try to, invoke their terms of service. But the point is, it's a conflict not just between circuits, but within the circuit. One says password sharing possibly go to jail. The other one says password sharing perfects authorization unless some second order revocation happens. So it's the Ninth Circuit arguing against itself.
And the reason I mentioned that in regards to your question is because both parties have filed petitions for rehearing en banc, asking the full Ninth Circuit to come in and address the case, which is actually what happened in the first time Nosal went up to the Ninth Circuit. The full court took it en banc. And so I'm not sure what the chances are of that. It's incredibly hard to tell. And they have time to do it. I think Facebook's brief is due tomorrow, so we won't know for a while, but I think that issue is actually kind of a new one. The password sharing is a new one. The Ninth Circuit is addressing it, but it's not something that there's a circuit split about. What there is a circuit split about is whether the terms of service itself can be a violation. Like what Paul was talking about, whether the intent of the employer can be used as a definition of revoking authorization. And so in some circuits, violating Facebook's terms of use is not even in the password sharing context, just creating a fake profile, using a fake name or a fake age or something. Yeah. So
being underage, right?
Or being underage, yeah, exactly.
Your
It's a good
Facebook
one.
has a limit. You're not allowed to, what is it, 13?
13, yeah.
Right, so if you're 12 years old and you have a Facebook
That's right.
account, you're violating Facebook's terms of service, and under some interpretations, that makes your 12-year-old daughter a felon.
And so that's where the circuit
I'm not
split is
making it up.
right now. But I mean, there's not a pending case that's ready to go to the Supreme Court in that. Also, the older cases are the ones that would find the 12-year-old guilty. All the more recent decisions are adopting a slightly more narrow interpretation of the CFAA that terms of service violations do not give rise to CFAA liability. So it seems like the court might just be waiting for circuits to figure it out, and because you have all the old cases going one way and the new cases going the other way, it's really hard to tell if the Supreme Court would ever pick it up.
So let's assume that the stricter, the harsher interpretation wins out, and now we have to start talking about penalties. What are the penalties under the Computer Fraud and Abuse Act?
So the penalties are why it's so, I mean, part of the reason why it's so crazy that we're talking about terms of use violations being a federal offense. Because a first-time violation can be punished up between 1 and 5 years, and then the second violation of 10 to 20 years. And so, and you don't actually have to have a conviction already. The charges stack, so you can, and most of the time, these cases are, people are charged with 3, 4, 5 counts of violating the CFAA. So a recent case was Matthew Keys. You might be familiar with that. This was a former Tribune company sysadmin who was a disgruntled ex-employee. He shared the information for getting into the LA Times website and on a web board. And somebody else then went in and used it to change the title and a little bit of text in this LA Times article. And it was pretty innocuous. It was up for 40 minutes, and he was facing 25 years. So he ended up only getting 2, but the fact that he was facing 25 is just kind of crazy for what in the real world would be considered vandalism. So, I mean, if the penalties, and one of the problems also is that a recent study was done, they asked a bunch of people, do you think that checking the weather at work violates the term, is that without authorization? Is your use of that computer without authorization? And the majority of the people surveyed said yes. And then when they said, okay, so how should this be punished? 60% said it shouldn't be punished at all, and 32%, I think, said it should be punished up like a parking ticket. Mm-hmm. And so, which is kind of exciting, I would say a little bit too much. But that just shows like this. So if we're talking about a criminal, like in some circuits, that would be a violation that could get you, like a prosecutor charging you with 25. I mean, if you check the weather every day at work for a year, you could be in jail for the rest of your life.
Sure.
So,
yeah, Paul?
Yeah, so I mean, really, what you've just described demonstrates one of the kind of overarching themes about overcriminalization,
yes.
which is that very broad laws and the limit on how they're applied resides in the good judgment and of the prosecutor in the exercise of his or her discretion. And, you know, having been a former prosecutor, I will say, you know, forthrightly that I think most of them do a very good job of trying to exercise that discretion wisely. But the real question is, who should be accountable for that exercise of discretion? Unelected, you know, prosecutors, or should the real sets of penalties be set by elected representatives who constrain the discretion more narrowly? So it's perfectly sensible to say, you know, we've got this wide 20 years thing, but we're going to count on the good judgment of the prosecutors and mean it. And it's not a nonsensical, but look at what that means. It means that you are asking, you know, basically a 30-year-old, you know, 5-year prosecutor who's in the district attorney's office in LA or the US attorney's office in Iowa, and they get to make the decision, which is, I think, a lot of pressure, too much pressure, and too much responsibility.
Gabe,
Yeah, actually, if I could just piggyback on that, I mean, one of the, you know, so I used to cover First Amendment, the First Amendment at the ACLU, and, you know, this is one area where there are, you know, two interrelated legal concepts that are supposed to counter prosecutorial discretion, especially in something like the CFAA, which it can be a pretty severe impediment to security research online. So it's one of those things where people who are seeking, bug hunters online, often don't know if what they're doing is without authorization when they're looking for those bugs. So for instance, there are companies that scan the entire internet, oftentimes many times a day. And when they scan that internet and touch a server, it's possible the owner of that server doesn't want them to touch that server virtually. And so in certain cases, those researchers will be chilled from engaging in research which has real social value in improving the security of our information, in protecting against the hacks that we've seen during the recent election. And so that's why there are these two concepts, especially one is that a statute that cannot be understood by a reasonably intelligent person is void for vagueness. It's unconstitutional because you don't know what's wrong and what's right, and you don't know whether you're going to be prosecuted. And then there's this other concept which has been slipping away in recent years, although in one notable case was re-upped by the Supreme Court, and that's the rule of lenity, which effectively says that Congress makes the laws, and if a law is ambiguous, the tie goes to the defendant. And that's a core concept, especially it's a core concept that provides a constitutional safety valve. And in the context of laws that potentially criminalize speech and expression, it's key because it protects against inconsistent or discriminatory enforcement. And so all of those points, is one of the reasons why so many civil liberties advocates are fighting for CFAA reform.
Just a quick point. I want to. The law professor in me wants to situate this in an even broader discussion, which is to say that all of our CFAA, we're here to talk about that, and it has some unique aspects because of its internet and access, the number of people who might violate it, and its free speech. But this is situated in an even more pervasive change, which is the extreme criminalization of the intricacies of the regulatory state, broadly speaking, most of which are completely unaware. Most citizens are completely unaware of. Harry Glade wrote a wonderful book, 3 Felonies a Day. That's his estimate of how many felonies each of us commit every day unknowingly as we walk around the street doing something that some regulation somewhere actually prohibits. I actually thought he was a little bit of an overestimate, but so it's 3 felonies a week. That doesn't make me more comfortable. But it is absolutely the case if you think very seriously about the strictures of the overarching state and its intricacies, that almost certainly every person in this room has committed one potentially chargeable act in the last week. I guarantee that. And if you gave me enough data, I could actually prove it for each of you.
Well, all 5 of you, in one way, shape, or form, are saying that the vagueness in criminal law in general, but in the Computer Fraud and Abuse Act in particular, is a bug. But I could imagine a prosecutor arguing that it's a feature. This prosecutor would say, and I think it'd be a well-intentioned argument, they would say, listen, computers are not like horses. They haven't been around for millennia. We don't have well-developed law like we do on horse theft, okay? So the vagueness is kind of necessary because behaviors, actions occur that any reasonable person knows are unwanted and ought to be viewed as criminal. You've got to give prosecutors the flexibility to make those sorts of reasoned decisions. I mean, what's the counter to that argument?
I think we've already kind of mentioned it a couple of times in regard to the rule of notice, the rule of lenity, where the law, it's a criminal law, it needs to be clear of what is unlawful behavior, and right now we don't have that. We have a law that was drafted a long time ago that is not relevant for how we use computers today, and I think.
I think that's right. And I don't think it's actually all that difficult to draw relatively bright lines, right? It's, Paul used the term breaking things, and that's really what this was supposed to be. You blunt force a password and gain access to a system that you clearly don't have authorization to access. You install malware on a computer. You set up a botnet. These are things that the CFAA was originally meant to cover, still covers, And we're into a space where, and this also goes to the overcriminalization and the draconian penalties, where in many ways the CFAA is used as a cudgel to force pleas out of defendants whose conduct is to force pleas out of defendants. And so that's at the core of the argument that we need this flexibility, right? We need the penalties, we need the flexibility to charge these things, but when you actually get into the details, I think you can tell when somebody has broken something.
I would go further, and I would say that your prosecutor's making a category mistake, which is to say that almost all of the problems that we see in the CFAA are when the computer is an instrument that enables the crime. It isn't the property stolen itself, but it is but that doesn't mean that it's a computer crime. It means it's a crime that used a computer. Now, some things are really bad instruments in and of themselves, like guns, and we have particular laws that penalize using them to commit crimes in particular because of their violent nature. But Nosal was guilty of trade secret theft, probably common law theft in whatever state in California. I don't know California, but it's not as if the law was disabled from it. The use of the computer was really just the way he did it. The number of times that the Computer and Fraud and Abuse Act is used in criminal cases where it's the computer fraud qua computer fraud, where it's actually unique to the internet and the nature of it, is relatively small, and they fit into the definitions pretty well. So he's just really it's like throwing a gun charge out there to enhance the penalties and demand it without the proof that computers are as bad as guns. And if there's any pro-gun people out here, I apologize for using that as an example. But at least they kill people. I mean, they're an instrumentality that has some violence in its inherency.
Yeah. There's also this weird sense in. I guess it's weird, but there's this weird sense in a lot of the cases that it's a fear almost of automation, right?
Yeah.
And that's, and so in one of the more controversial cases, the Weave case, AT&T was storing emails in public. They weren't protected by a password or any other access protection mechanism. But what they were doing was using really long addresses so that they were hard to guess. And in the Weave case, this fellow was prosecuted for effectively guessing what those addresses are in automated fashion, and then finding 114,000 email addresses, and then publicly posting them, which not good facts, but was prosecuted for doing that. Whereas if he were to do it in one case, right, if you were to access a hard-to-find website in one case, I don't think anybody, a public website without an access protection mechanism, I don't think anybody would say that if you access that website one time, right, and you don't deploy a worm or a bug or some other piece of malware, that should be a federal felony. And that trend, I think, flows along a lot of the cases where when you do something in an automated fashion, there's this fear of automation, whereas if you did it one time, it wouldn't be.
That's actually sort of why I objected to the characterization of Joshua as an evil computer. Because I in some ways I'm sociologically very serious.
Yeah.
There is this image that if it happens in a computer in a mechanistic way, there's something sinister about it. And it mostly comes from people who haven't got a familiarity with computers. Now, I mean, I'm 57, so mine is all post-computer. I mean, I grew up before the internet existed, right? So it's learned, but I've managed to break through that fear. But there are a lot of legislators, a lot of users who think that the fact that it is a computer is in fact like being like a gun. It is dangerous.
Reply All actually did a podcast called The Law That Sticks about the CFAA and specifically the Matthew Keys case. And that law that sticks concept is exactly that this is anything that is involving a computer, you can just slap a CFAA charge on it because it's so big that if nothing else sticks, that one will be able to because there was a computer involved. So if you're interested, it's a good one and it only takes 3 minutes.
Who did it?
Reply All.
Okay.
You know, on the question of penalties, I'm thinking about what Paul said about how you can use some of these old common law concepts on these new technologies. And I read a really interesting paper from a colleague of yours at George Washington Law School, Paul Orrin Kerr. Orrin made the argument that with penalties and the Computer Fraud and Abuse Act, we always think about economic loss. We shouldn't think in those terms. We should think about these as trespass cases. Hacking is just trespass. Is that a better model for thinking about it?
Well, I think it's a better model because it's a little more consistent with what we think of as really the wrong thing, which is, trenching upon property which has, no trespassing. Violators will be prosecuted, posted out there. Personally, though, and I've said this to her, I want us to get away from analogies. Computers are computers, right? Trespass is trespass. We can, build the law to fit what it is. I think another problem that we didn't really discuss is that this system of operation changes too rapidly for our legal structure to keep up. 1986 is a long time ago for a law, but even if it was a 2006 law, which would be a very recent law, I would submit that it was probably dated in some way, because many of the techniques that we talk about access, many of the uses that we put computers to, how many of you have, iPhones, right? They were introduced in 2005, right? So a 2005 law wouldn't even cover something that every human being in this room has. I include you if you're an Android user as well. So that kind of, the rapidity of change makes law very, very difficult and suggests that, we shouldn't just run willy-nilly to characterizing it or categorizing it, at least to me. That's philosophy.
Orrin, I think, thinks that trespass would be a good way to think about it, because then we could bring in norms about what is and is not trespass on the internet. But I agree with Paul that you're going to run into judges who are like, okay, trespass, I know trespass law, let's talk about physical land, and then draw analogies there. As a lawyer, I get that all the time, and I'm trying to draw away from analogy, because if you're trying to analogize the internet to the real physical things, you can make one, but you could always make up something that steers you the other way, because they're not the same. So it's very challenging.
Yeah, and I think interestingly, Professor Kerr agreed with the result in Nosal 2, but he disagreed with the analysis. I think his reasoning was that the defecting employees were not acting as agents of the executive assistant who shared the password. So it would be one thing if you share a password to go in and do some banking, or to, in the physical realm, you give somebody your key to go in and water your plants, but it's quite a different thing if somebody gives you their key and then you go in and steal something.
Yeah, I actually think that's a more useful old concept, right? Which is, if I give my password to Gabe, there's either implicit or explicit that he's going to use it to download a movie, not to download 300 hours of porn and put it on my computer.
6 felonies this week.
Yeah, there you go.
There are a few specific cases I want to ask about, but the CKI staff is indicating that it's audience Q&A, 5 minutes till Q&A. Let me ask about a couple of cases. There's one that we talked about on the phone I think is interesting. It's the Lori Drew MySpace case. Jamie, can you give the details and talk about that a bit?
Sure. So that was a case quite a long time ago where you had a mom. She was upset with a girl that was in her daughter's class, so she went online and created a fake MySpace profile of this cute boy, put up a photo, and then kind of used that to send messages that, kind of harassing messages to the girl, that girl ended up committing suicide, taking her own life, and it was like a really tragic case, really tragic details. And so the government filed charges against her on the ground that she violated MySpace's I always want to say Facebook, but this case is way before, because she violated MySpace's terms of service. But an issue in the case is she never actually read MySpace's terms of service. She didn't know she was actually violating. So it's a notice, there's a clear notice issue there. Yeah, those are the facts.
Yeah, I'm old enough to remember Friendster, by the way.
Oh, yeah.
Just, Paul, you want to say
I don't
something?
remember Friendster.
I remember Friendster.
8 more minutes. What about there was a really awful case that you were talking about, the case out of Ohio involving the rape
Oh, yeah.
and the video. Yeah, what is the...
Well,
what
I mean,
affects
that was just a case that shows the differing of the penalties. So there was a case involving 2 football players and an alleged rape, and then there were a couple years later, you had 2 individuals who hacked into a computer and an email account and obtained, video showing that this person did not have the capacity to consent. And so, but then ultimately, the 2 alleged assaulters only got, I think, 2 and 1 year sentences, and the person who did the hacking to find the evidence was facing 16 years under the CFAA. And so we're talking about like this really serious, violent, physical act, 2 or 1 year's sentence, and then facing 16 years for, I mean, it's I'm not condoning the hacking, but it's just out of whack with what we think
See,
is
those
bad.
2 cases actually make the point. What Ms. Drew did was horrific.
Yes.
Right? But there's criminal laws on the books against harassment and bullying and the theft of the video. I'm sure it could have been addressed in that without a CFAA charge as well. Again, in both instances, the computer is almost incidental to the nature of the crime.
Well, let's go to audience Q&A. I would ask if there's a microphone floating around, but I guess...
We don't have any working mics, so...
We don't know why we're wearing these.
I don't even really know why we're doing this,
Yeah,
yeah.
so
I guess we were just optimistic that they may work at some point. Any questions from the audience? How about right here in the second row?
Paul, recognizing your reluctance to use analogies here, I'm having trouble coming to grips with your concerns about intent and authorization. As to intent, you mentioned in the real property world, the equivalent of the no whites on this website.com would be a keep off my lawn sign, no trespassing allowed, regardless of what you did when you were there. If you didn't commit a felony, you wouldn't be committing a burglary or a breaking, but you'd still be trespassing. On the subject of authorization, the second question, you talked about the idea of a private citizen communicating it perhaps in a vague way. I'm immediately thinking of sexual assault law, where of course consent is the real determinative factor. So, any thoughts or guidance you could provide on those 2 issues?
First off, it isn't cut and dry, and so I agree with you. But I think the Weave case is a perfect example where the consent, where the technical and the objective consent are completely at odds. They ran a website that had publicly available all of these passwords and email addresses, right? And they did it as a service to their customers. Clearly, they intended in some subjective intent that their customers be the ones who use it, not Weave. But on the other hand, they took absolutely no technical precautions. So there's no signage up there that says don't do this. We are left to infer their intent from the fact that it's an obscure site. Is Weave's access criminal? Is he acting with the intentionality of breaking a known prohibition that the company that operated the website has expressed? In the absence of a sign, right, which is, in the absence of white people don't look at this website.com, it's hard to say. I think he had a great case. He wound up getting off on jurisdictional grounds, technical grounds. The court decided not to decide. But I think that, objective manifestations of consent in a technical context are much more relevant. I think I would probably reject, therefore, the analogy to sexual consent laws for a whole host of reasons, at least in part because it's totally fraught with uncertainty. But it also involves a dynamic where disputes about consent are always reduced to, I mean, unless you wear a big sign that says no, right? Always reduced to more, frequently reduced to more subjective intent. So I'm a strong backer of the idea that you have to manifest objectively your desire. That's why I kind of am with Facebook on the cease and desist side of this. The password sharing, that's not manifestly objective, that I can't share it with my wife. In fact, I do share my Facebook password with my wife. But if I got a letter from them, said, "Dear Paul, don't tell Katie your password," then I have to stop, right? Because they've objectively manifested their intent, either technically or with an express declaration.
Anybody else right here?
This is for Jamie. So what do you think would be the best way to fix the CFAA or reduce the amount of harm that it causes?
Funny you should ask.
Well, so I mean, I think it's clear, we've made some progress in the courts, right? Like there were some circuits that are adopting the more narrow interpretation of the statute, but it's clear from the past 2 Ninth Circuit cases that we're not getting, it's unclear again. We're not getting consistent results. We have people emailing me concerned about needing to access needing to log in to use their loved one's password because they're their caretaker at this point, and they need to do this. Is this going to land them in jail? And so I think that we need Congress to step in and modify the law in a way that fits where we are today. And like Paul said, it's going to need to be adaptive to changes in technology because technology is changing at an exponential rate and our law moves very slowly. So we need that, and I think we need to look at the sentences and change that and give courts more leeway and prosecutors less discretion.
Yeah, unfortunately, Congress has gone in the opposite direction historically, and right now is going in the opposite direction. There's a bill pending that would further amend the CFAA.
I'll answer it easy. Make it a specific intent crime. I mean, that's the kind of issue we were. Make it that the crime it arises only if you knowingly, not if you knowingly do the act which constitutes the offense, but if you violate a known prohibition. So proof of knowledge of the prohibition, which can either be technical or through notice, is an element of the offense. That would cure a large fraction.
And there definitely are countries that are doing it, not the US, but there's other countries that have computer crime statutes which require intent to cause harm, and they also include specific carve-outs for security researchers. So if all you're doing is looking for a bug, and that's all you do with it is you find the bug and you give it right to the company, and you don't exploit it in any way to your benefit, then that's not going to be a CFAA violation. And right now, our law deters security research, and it is a burden into innovation too. So it's bad on all sorts of different levels.
I think members of Congress in California would be interested in advancing amendments of the kinds you're talking about. Is that not happening?
Nobody in Congress ever got rich making the criminal law narrower.
Yeah.
Well, there is.
That's why we're here.
Well, there's Aaron's Law, which was introduced by Representative Zoe Lofgren from California, which would make it explicit that the violation of terms of use agreement can't be a violation of CFAA. So that's one proposal that's been out there.
Yeah, it hasn't gotten.
No.
Brian, the third one.
What if any of some of the First Amendment implications of the CFAA?
Gabe, you're an old
You're
ACLU lawyer.
the one guy.
The ACLU actually just
There's
filed
a
a
case.
lawsuit on First Amendment grounds against the CFAA.
Yeah, so, well, and that's probably so it's in the security research realm, I think, where the clearest First Amendment implications are. And the ACLU's lawsuit argues that in the real world, one of the key things that researchers do in order to identify discrimination in things like housing is they'll audit, they'll actually pose as potential tenants. And they'll come in an African American and a white and see if there's a different response. And that's actually how it works also online. There's a lot of there's a huge potential for algorithmic bias, where bias that's just inherent in humans, it somehow gets baked into automated processes. And one of the things that security researchers are doing is looking for algorithmic bias by, for instance, using something called a sock puppet, which is effectively a fake social media profile or a fake account on another website. And in many cases, researchers are actively chilled from doing that kind of audit research because terms of use will prohibit, this is the real name policy, terms of use will prohibit using a fake name or a fake profile to access the site. And so that case is currently pending. I think the DOJ just responded to the ACLU's complaint.
Motion to dismiss.
Right here in the third row.
Yeah, I'm curious for the specific intent argument, how would you capture that in light of the Netflix argument, that if you share your password, forget someone in your family, but you share it with friends, someone who is clearly not your roommate, not part of your account, separate from your account, separate outside of the terms and services agreement that you signed when you agree to use Netflix. When you're looking at a specific intent argument, I think under things like the Copyright Act, there is definitely still an argument that you're intending to commit harm there, because it's very much coming into a licensing situation that you're still using movies and accessing art that you don't have a license to access. And so how would you go about narrowing that and defining that insofar as framing that situation?
I don't think it needs, we've had specific intent rules for hundreds of years. I think it's now you become case-based, right? I think if I have a Netflix password and I share it with my wife, they're going to have an awful tough time trying to prove that I'm attempting to appropriate the value and transfer it to my wife. If I share it with 300 of my frat brothers, right, then they're going to have a better case. So it's going to always turn on scope, duration, volume, numerosity, things like that. And what?
The harm.
And all of which gets to the magnitude of the harm to Netflix in the end, right? If I do it so that they lose 10,000 downloads this week, I'm probably going to go to jail, right?
Yeah.
If it's one with Gabe, I shouldn't.
Again, charges dropped.
You keep dropping the charge.
I keep doing things to me.
Never sit next to Rosenzweig on a panel.
But the Power Ventures case is a little bit interesting, though, because you could in Power Ventures it was cease and desist, so it's like an official don't do this anymore, and the court put a lot of stock in that. But you could imagine a situation where you go to Netflix and then they pop something up and says you can't, thou shalt not share your password, right? And that's I think a tougher case. It's also problematic in the context that I was just talking about with the ACLU case, where what if you are doing this auditing, they find out that you're a fake profile, they send you a notice saying thou shalt not use a fake profile, when what you're doing is seeking to identify this algorithmic discrimination. So there's actually social harm even there. But I'm not sure how you square that circle.
You have to have a carve out. You have to have a carve out for legitimate
Which is
civil rights and social research, and then that also has a definitional problem because, of course, one man's carve out is another man's excuse.
One of the other reasons the cease and desist letter is troubling is because the court didn't actually say like it has to be a cease and desist letter, it has to be this. It just said they had clear notice that this wasn't allowed, but then it seems like the court's drawing some kind of line somewhere between a terms of use policy that says, Facebook's terms of use policy, for instance, says you're not allowed to share your password, with some other kind of subsequent notice, which contains a computer use restriction. And so where that line is drawn is not clear from the court's opinion, and it also seems kind of like a disingenuous line to draw, because we're talking about use of a website and not access. So that's another problem with the court's ruling.
All right, well, I'm afraid we've got to draw the event to a close. If you've got additional questions, you can come talk to the panelists afterwards. Please join me in giving our three panelists a round of applause.